at Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our main reason for being is that we're trying to make ourselves as affordable as possible to make sure that the working person, man or woman, has representation in both criminal courts and family law courts because the issues involved are so important that those folks should be represented by competent legal counsel. On today's episode, I would just like to take a moment to express and explain child custody modifications in Massachusetts. As with all modifications in Massachusetts, the modification has to come about. There has to be two requirements for a modification. First, there has to be a substantial and material change in circumstances since the last court order. And number two, that the proposed change is in the child's best interest. So let's take a moment to examine both of those things. So there has to be a material and substantial change in circumstances. So that, as it sounds, is not a trivial sort of change. It's not a minor change because courts don't want people coming back to modify child custody orders for little or no reason. For a small change, the court doesn't want to keep hearing things and possibly change. Tweaking the child custody situation. It has to be a material and substantial change. So that's the first hurdle that you must meet to show that substantial change before the judge will even hear what your proposed change would be. So you have to get over that first hurdle in order for your case to continue. And the second thing is the proposed change must be in the child's best interest. Always keep in mind that in the probate and family courts, when dealing with children, the main thing the courts look for is that they want everything to be in the child's best interest. Of course, that's open for interpretation, and two people can have legitimate disagreements over what is in the child's best interest, and that's where the battle oftentimes comes in, and that's what it's up to the judge to make a determination of what is in the child's best interest. So let's look at a couple of reasons why, a couple of examples of what a material and substantial change would be. One of the things is that if one of the parents moves out of state or wants to move out of state, if there's a typical child custody arrangement with parenting time, where a non-custodial parent gets the child, say, every other weekend and 1 week night per week. If the person is now many more miles away, out of state, that arrangement's not going to really work out very well, just logistically. So something would have to be changed in order for the child to continue to see that parent on a regular basis. Usually that means that that parent would get perhaps fewer visits with the child, but they would be longer in duration. Something along those lines. Another reason for changing a child custody situation would be if one of the parents is continually interfering with the parenting time or visitation of the other parent. So if somebody's getting in the way of so, for instance, if you are supposed to have your child, say, this weekend, and the custodial parent won't let you see them or wants to hold off, push back the time that you can pick them up or push forward the time you need to drop them off, if they're getting in the way of your time with the child, that could be a substantial and material change in circumstances. Also, anything having to do with putting the child in any kind of danger, so any substance abuse in the home by one or either one of the parents could give rise to a substantial change in circumstances, certainly. So those are the kinds of things most commonly that we see. And the other thing is that just as children get older, their lifestyles change. So a child custody situation that was put into place years ago may very well need to be changed because the child's older now. They're involved in activities in school, or they're working, or whatever. Their life changes. So a child custody arrangement should change in order to accommodate that new lifestyle. So that's the first hurdle, is the substantial and material change in circumstances. Next, you must show that it is in the child's best interest. And again, that's up to interpretation, but really the court looks to, they want stability in a child's life. So they don't want to upset the child's daily routine or overall lifestyle, unless there's a good reason to do so. They certainly will do so if presented with the proper information that such a thing, such a change would be in the child's best interest. So the judge wants to keep stability in the child's life. They want them to continue in the same school, with the same friends, in the same neighborhood, if possible. They don't want to upset the child's life any more than need be. The child's wishes can sometimes come into effect as well. So let's take a moment to take a look at that. A lot of times people will ask us, well, my son or my daughter wants to spend more time with me or wants to live with me or something like that. Can they just tell the judge that and have them and have the child custody changed? Well, not necessarily. A court will take into consideration a child's opinion depending on the situation. It's really a maturity sort of analysis that the court looks at. There's no bright line where where the age of a child comes into play, where there's no rule or no law that says, at 12 years old they can express their opinions and the court has to go along with it, or 14 years old, or whatever it might be. But the court will take into account the child's wishes, the more mature that person is. So the older the child, probably the more likely a court will listen to their opinion. The other thing is, a lot of times courts don't want to have a child express such opinions because it puts the child into a very difficult situation. The court doesn't want to put pressure on the child to say, I want to live with mommy, or I want to live with daddy, whatever. And the court doesn't want you or your ex putting any extra pressure on your child to say something like that. If the judge is going to listen to a child's wishes, and they sometimes do, usually they don't want to do that in open court. They will take the child back in chambers so that the child can express their wishes without going on the record and so forth, and without having to go on the witness stand and so forth, because that could be very traumatic. I mean, that's traumatic for anybody to have to take the witness stand, but certainly for a child, for a young person to have to do that, especially when mom and dad or the parents are involved. You certainly don't want to give the child any undue pressure as far as that goes. There are situations where there are emergency situations where you want an order that needs to be heard right away. So instead of a more routine situation where the child's lifestyle has just changed over a number of years, that can get scheduled in the normal course of things for a hearing to be heard before the judge. But in an emergency situation, so let's say that one of the parents is having a substantial substance abuse issue, or there's an allegation of child abuse or something along those lines. Obviously, you need to get to court right away because the child's safety is at risk, and nobody obviously wants that to happen. So there is a fast track, in other words, but it has to be a real emergency. Sometimes people will try to push things to try to make it sound like it's an emergency when it's just something you want done right away, but the child is in no harm. There's no particular fear for the child's safety. So keep that in mind. Even though you might think it's an incredibly important thing and needs to be heard right away, the court may not agree with you as far as that goes. So how to win a child custody modification? One of the things, you just want to be present in the child's life. You want the judge to know that you are a good parent, that you have been there for your child all along, and that you still will be. So if you're a non-custodial parent, make sure that your child support payments are up to date. Make sure that you are participating in your child's life. So go to their activities, their school activities. If they're into sports or dance or whatever it might be, make sure that you're supportive of that. Be involved in the child's school. So go to the parent-teacher meetings and so forth. Again, you just want to show the judge that you are an involved parent, and it would make sense for the judge to give you this modification because you are involved in that child's life. So again, at Afford Law, we practice criminal and family law, and we do so at usually a greatly reduced rate from what other firms charge. Here's the reason why we're in existence. For far too long, the working man or woman has been pushed aside by the legal services community. What happens is if somebody is indigent, that means if they have basically no money, they qualify for a court-appointed attorney or legal aid, something along those lines. If somebody makes a lot of money, they can go out and hire whoever they want to on the open market. Typical fees for typical hourly rates for attorneys is probably $250 to $350 per hour. If a regular working person is confronted with a family law matter or a criminal law matter, all of a sudden they have to come up with a large amount of money they may not have. But the issues are so important when talking about your family, your children, or in the criminal side of your actual freedom. You should not be unrepresented when you're walking into court. So what we do is we charge all of our fees on a sliding scale. So what happens is we take your income, we take the amount of people in your household, we have a formula that comes up with our hourly rate for the family law cases. And as I say, it's usually drastically less than other people charge. We use affiliate attorneys who are experienced, compassionate folks who agree to take on these cases because it's the right thing to do, and they want to make sure that everybody is represented in court. So if you have any questions, please feel free to visit us at affordlaw.org. Please feel free to look around. We have a lot of resources on the website. If you'd like, we'd be happy to talk to you. Book a free, no obligation appointment. It's virtual from the privacy of your own home. There's no obligation whatsoever. At Afford Law, we're making justice affordable.